Good afternoon, everybody, and welcome to this IES webinar. My name is Amir, and I'm from Curtin University. I'm also serving as a vice chair of the IES WA chapter. Today it is my honor to introduce you Mr. Paul Fong to giving us a talk about patents, a tool for your business. Before starting, I would like to give a quick introduction about the, Paul Fong, activities. So Paul graduated from Curtin University with a Bachelor of Engineering Computer Science, and he is a registered patent and trademark attorney in both Australia and New Zealand with over 25 years of experience. He has worked with a range of clients from local startup to major multinationals, and in a range of technology from mobile telephony and software application through to road paving equipment and screening technology. So I would like now to invite Paul to give us his talk. So Paul, are you ready to go?
I am, thank you. Yeah. And thank you for that introduction, and thank everybody for joining us this evening. I guess just one shout out is I apologise in advance if my 7 and 9-year-old decide to start World War III. I'm doing this presentation from home, so I've impressed on them to be quiet, but we'll see how things go. So I guess if I can actually move the slide, I guess I'm a patent attorney, so you're going to expect me to say that you should patent your inventions, and patents are very important, and certainly I do think they're important, but I also don't think that a patent is what you need for every solution. There are times when a patent is not appropriate. For example, if you're a startup business and you've only got $100 and you can either spend it on getting your product to market or towards getting a patent, it would be silly to spend money on a patent and not have a product in the market. So it is just a tool that you need to use. And so I'm an advocate for understanding what patents are, knowing what they are, how they can fit into your business, but then making a decision as to whether they're appropriate for you. And in some cases, they would not be appropriate. I guess I should put a disclaimer out there first, so please don't rely on anything I'm saying here as legal advice. If you do have a particular circumstance or a problem, then please seek formal advice for that issue. Today I was going to talk about what a patent is and how you can go about getting a patent. If anybody out there is sort of experienced in obtaining patents, then those two steps are probably going to be not new to you. And then I'm going to touch on what a value of a patent might be, and then sort of who's doing what. So this is where you can see what's going on in the industry and what your competitors are doing. So a patent is just one form of IP, and when I say IP, I'm not talking about a protocol, I'm talking about intellectual property. So I'll try not to use my version of IP, but just please keep in mind that if I do happen to slip up and say IP, that I am talking about intellectual property. And you can think about every time that you go out and you buy a new phone or something, pretty well all these forms of intellectual property are going to be involved in it. Certainly anytime you're using your mobile phone, you probably aren't even aware you're actually using patents that are owned by Ericsson in terms of the telecommunications. You pay for anything with your credit cards, it might be a Visa or an Amex or a MasterCard, so there's trademarks. And if you hold up a phone to any teenager these days, they can probably tell you where, who made the phone and where it's from. So certainly there's different forms of IP. Now I'm going to be concentrating on patents, but before I should mention copyright as well, though, because certainly within this industry, and in particular if you're in the software, there is a consideration out there and belief that all you need is copyright, and certainly copyright is important and it has its place. But copyright protects the expression of the idea, but it doesn't protect the idea itself. So an example there, I guess, if you think about a school classroom and a teacher asks all the children to write a story about time travel or a boy wizard, the concept and the idea is going to be consistent across the class, but hopefully if there's no copying, all of them have expressed it in a different way, and that's the same with copyright. It's how it's expressed that you get to protect it. So source code is protected, but if somebody else has a great product out there and I want to do the same thing, I can take the concept, I can get a whole bunch of coders to cut me the code, and they can just be in a room where they don't have anything else, and they can come up with the code exactly themselves. So potentially we could have exactly two identically functioning projects or products. There's no copyright infringement because that's not what's copyright is protected. In those scenarios, that's where you need the patents. So the patents are protecting the concept and the copyright protects the expression. What I will say though is if you do have any logos, code, copyright, text, whatever it is that's being prepared by somebody, particularly if they're external to your company, that you probably should make sure that you get a formal assignment of the copyright to your company. So for example, if you have a logo designed by somebody, yeah, certainly you can use it, but it doesn't mean that you own the copyright. So what is a patent? Wikipedia have probably got a pretty good definition there. It's something that gives the owner of the patent the exclusive right to use that invention for a period of time. Really, what you're doing is you're making a contract with the government, and what you're saying is, I'm going to give you and the public this new technology that no one's ever heard of, and in return, you get a monopoly for a period of time. So it's a monopoly and an ability to stop somebody doing what you've invented. It's not a right to do it yourself, but it's certainly a right to stop somebody else. And the thing is with patents is that quite often there's almost a dual use of the term in society, and people talk about patents as being a lot of different things. Dean Kamen, he's the guy who actually invented the Segway and things like that. He actually talked about it being an assemblage of technologies that you can put together. So if you put together something, a whole bunch of pieces, and you put them together in a way that nobody else ever thought of, you've got an invention, and he's spot on. That's what an invention is, but it's not a patent. The patent is the reward or the award that you can get for actually coming up with that invention. Now, just to give you a bit of an example, if you're, this is a very basic example, and it's an example of what a patent claim is, which is perhaps the most important part of a patent. If you think about, if somebody goes out prospecting, they might stake a claim over a certain area, and that's their area to prospect. And they've staked the claim, nobody else should be prospecting in their area. And that's exactly what a patent claim is as well. The claim is defining what somebody else can't come and do. And this is just an example to give you an idea of what we've got here. So, we've got, it's a bottle, it's got a first chamber, which is over here. It's got a second chamber, number 20, and that's sealed from the first chamber. So you can sort of see there that they're two separate. In the second chamber, it contains particulate matter. Now, we patent attorneys, we like to use nice, simple, easy language. So rather than calling something a shovel, we might call it a ground engaging implement. And that's what we've got here. So we're talking about particulate matter. In the example of this patent, they're just talking about rice, obviously, so it makes a nice sound when you're shaking the maraca. But what we're using the word particulate matter because it may not be rice that we want to cover. We don't want somebody else just going off and perhaps using seeds in there instead of rice. So we use other language to try and cover off those variations. And the rest of this claim talks about other things. So, it's got a removable enclosure, so it's got a lid on the top, essentially. Now, if somebody else goes and makes something similar, but they don't include one of these things, then they don't infringe those rights. So, for example, if I leave off the lid, then I'm not going to infringe what's here, so I don't infringe these people's claims. And that's why the claim is really important in terms of a patent, because it is defining what rights you have. Another example of an invention. Anyone who out there, likes cricket, you'll be aware that once upon a time, then no one actually wore helmets. When the first helmets came out, they all had this nice protective grille, but it couldn't be adjusted. So depending on the size and the shape of somebody's head, sometimes this was actually uncomfortable. It didn't work. So what Albion came up with is they actually came up with a way that this protective grille could be both moved forward and backwards and up and down so that it could actually suit the person's head and that they could be comfortable, hopefully for a long time out in the middle. So what it was an invention for something that was new and hadn't been done before. And that's where we come to what an invention is and what it's defined. Now, for those who like reading legislation and statutes, I've got on the screen there what the important part is for the Patent Act, and it's Section 18, patentable inventions. For everybody else, what you need to know is that for a patent, it has to be novel, it has to be inventive, and it has to be patentable. So if we look back at the helmet here, a helmet was known before. So Albion weren't saying that they'd made a helmet. What they were saying is they made a helmet that had the adjustable protective area, and that's what was new. It never been done before, so it was new. The next question is, was it inventive? Now, if we think about it now, it's pretty obvious that you would want to make it adjustable to fit, and that would probably be what you would expect if you were going out to buy a helmet. But back then, when it was done, it wasn't so inventive, it wasn't obvious, and so that's why it was considered to be inventive. And then when we look at patentable, it's whether it's something that's suitable for a patent. And perhaps the better way or the easier way to consider this is to actually look at what's not patentable. So discoveries and ideas and schemes are things that are not suitable to obtain a patent. So for example here, the idea of putting a man on the moon, or perhaps I should say Mars these days, that idea itself is not patentable, but how you go about doing it can be patentable. So certainly whilst an idea or a scheme of itself is not patentable, or an algorithm, using and implementing those can be patentable. And we'll come to some of those examples. So what's happened is over time, the patents has evolved, and that's why they're defining what some of these things are. So back in time, patents were really only obtained for mechanical devices or physical products at the very least. So it might have been a particular combine harvester, or it could have been parts of an engine. And so it was all these hard things that someone you could pick up, you could hold, you could look at, you could play with, and they were certainly physical. And then NRDC came along, which is the National Research Development Corporation, and they had been working on a problem. So farmers had a problem that there was obviously weeds in their crops. They couldn't just go and spray the crops with herbicide because it would actually kill the crop, which is obviously somewhat counterproductive. Now, what NRDC came up with, they came up with a method that effectively used a selective herbicide such that farmers could spray it on the crops, it would kill the weeds and it wouldn't harm the crop. And they went and tried to get a patent for this one, and it went through the court system, and it was actually found to be allowable. And there's terminology there that was artificially created state of affairs. Now, this was really a seminal case and certainly groundbreaking, and all of a sudden, it wasn't just a physical product that you could patent, but it was actually a method that you could patent. And that was back in around 1959. So even so, it's not that long ago. If we fast forward a few years, around early 90s, for those that sort of my vintage or older, you might remember that when you're in school and you had to plot things on graphs, you would work out where the x-axis is, the y-axis, put all the points, then you get your rule out, you draw lines between, you get nice sharp lines between each of the points on the graph. And certainly that was also the way that things were on computer screens. For those that do remember it, you might remember you had nice straight lines joining all the points on the graph, and that's you could see the results. What IBM did is they actually used a known formula to do a curve of best fit, and so that rather than the screen, rather than joining these points straight up, had this nice curve. And certainly in terms of computers and technology, that had never been done before. There was certainly a bit of things about, well, you can't patent software, it's not, it's not patentable. But what the court found was that it was actually, what they did was foreign to the normal use of computers. It'd never been done before. And so it was actually something that was patentable. And so this was another leap forward for people like myself in particular that had a background in computer systems and software, because it meant it was clear that software was something that you could patent. So we had the physical mechanical devices, then we've moved into methods and processes, and now we've actually got it, the court saying that software is patentable. We now move forward again a few more years, and this is more relatively recently times. So RPL Central, so they actually identified that there are a lot of standards and qualifications out there, and the requirements for each of these are not standardized between the various groups and companies and organizations. So what RPL Central is, they actually came up with an automated method that would actually look at the requirements of a particular standard, and it would automatically reword and reframe that requirement into a question that normal everyday people can understand, so that somebody could go on to use their system. The question would actually come up on the screen in a sensible question, and the person can say, yes, I do that, and they can move on, and then they can find out whether they actually meet a certain standard. Now, one of the things that actually came out in the court and the decisions was that it was impossible to do this as a human being. The computer was absolutely necessary to do this. It couldn't be done without a computer. However, in these cases here, what they found was that that was well and good, but that wasn't sufficient. They decided that in this case here, what it really was just a business scheme, and so therefore it was not patentable. And so we've got a bit of scope there in terms of what is and what is not patentable. And these court decisions are what patent examiners look at now when they're trying to assess whether an application is worth a patent. So examiner, and I've got examples here of, I guess, the software side of things, because that's probably the area that's a bit more contentious currently, and probably more the evolving area. So that's why I've talked about the software. So what an examiner is going to do, he's going to see the application for a patent, and he's going to look at what the invention in substance is. Now, I'll say here that patent attorneys, as a profession, we probably don't agree with the approach of that the examiners, how they work out what the substance of the invention is. Now, I can say that, but I guess it's also a bit like somebody complaining about the umpiring decision, in the grand finals on the weekend, which affects it. So, what I say, it doesn't really matter at this point in time. The examiners in some ways are the gatekeepers, and we need to try and talk to the examiners and persuade them as to what the substance is and to come to our way of thinking. But that's what the examiner is going to be doing it. And then if we look at software, what they're going to be doing is they're going to be looking at, and it's not just software, it's other inventions as well, but certainly on the software side, the examiner's going to be saying, well, does it result in an improvement in the computer itself? Does it solve a technical problem within or outside the computer? And if you think back to the slide that I put up in relation to IBM, this is some of the language that the court said back there. They wanted to know, was there an improvement in the way that the computer operated? So the examiners are looking for both a technical problem that you've solved and also a technical solution. So in some ways, what we need to think about there is, what is the improvement technically in the functioning of the computer and the technology, as opposed to necessarily what is the improvement in the business method or scheme of doing things. And sometimes this is a pretty difficult concept to come across. If you're in a larger company, you've got the technology guys that have actually come up with the solution, how it works, and then you've got the marketing people that are spruiking and talking about how good the invention is. They're talking about the advantages to the end consumer, but from the technical perspective, we need to be actually looking at what the solution was. And I guess honouring what the tech guys have come up with. So that's sort of a background about what patents are and some of the process. But how do we go about getting one? So if we're just looking in Australia, the first thing we need to do is come up with the invention, obviously. Now, what I will often talk to people when they come to me and they say that, you know, they've got this great idea is, I'll ask them whether it's possible that they could actually get it themselves a working prototype. Because if they can, I certainly strongly recommend that, because invariably from that CAD design, when you go through to making those prototypes, there's some sort of change that's necessary. And I get it, and I've had so many people talk to me and they say, you know, I'm an expert here, I do this all the time, I know it's going to work, no, I've not made it, no, I haven't modeled it, but I know. And yeah, sometimes they will, sometimes they won't. But if they can make a prototype, then that's what I'm going to recommend that they do. It's also good from a timing perspective in terms of the process as well, but certainly they prototype. If they can't do it, they don't have the capabilities of doing the prototype themselves, well, then we are going to have to proceed without that in some respects. Because one of the important things you need to do is to keep the invention secret until you've filed your application if you're looking at a patent. There are some get out of jail clauses around it, but in terms of your thinking, you should think about trying to keep it secret. So once the invention's come up with, they need to talk to the attorney, and we draft what we've called is the provisional patent application. Now, once this application is filed, you're then free to go about telling people about your invention and taking it to market. So it puts a flag in the ground, this is what I'm doing. We've got then 12 months before we file the next part, and this is a complete application. So in that 12 months, the idea here is that you might have actually identified a little few problems or some improvements, and therefore we can include it in that complete application. Now, while you filed the application 12 months ago, it's still not public, so your competitors can't see exactly what you've got. And it's actually not going to be published until 18 months from when you filed that provisional application. So it's great that you can actually still keep it secret this time whilst you're sort of expanding and developing and getting the product to market. Now, the next step that goes through is an examination phase. And this is where the examiners are actually going to look at the invention and they're going to say, yep, this is okay, or no, I think there's some problems here. There's things like, no, it's been done before, or it would be obvious. And we can file responses back to the examiner and they might issue further reports and respond to it. And certainly that's where we need to convince the examiner, and we might amend the claims so that they are allowable. Once the examiner is satisfied and will allow it, the application goes through to acceptance. Now, at this point, anybody else can oppose the application if they don't think that it should be granted. So certainly that does happen. And if you think it's going to negatively impact on your business and you're aware of the application and it's going to stop, doing what you're doing, but you've been doing it for years, then you probably want to oppose it. If there's no opposition or the opposition fails, then it goes to grant. And that's the process for Australia. If we're looking at more international, so you're thinking, Dr. Even Austin Powers, you want to take over the world, then this is the option for you. And it's a bit similar. Again, you come up with the invention, we file the provisional patent application, but then rather than file the standard application, we file what we call a PCT application. And this really just gives you rights to go most of the countries around the world. Again, it's still published 18 months. In that international phase, we're going to get a bit of a search, so we're going to know what's happened before, and we can also get some sort of a quasi-international examination in there so that you have an idea whether your application has legs. So if in this stage here, if it turns out that actually someone in Canada has done your exact invention, you might go, okay, well, I'll pull up stumps. Or you go, wow, it's looking good, I'm going to proceed with this one. And then we file the national applications, and that's where we file in each country that you want it to be granted in. And then it goes through the national laws of that country. So there's examination like in Australia, and it goes through to acceptance and grant. Now, we don't have to, that's sort of a notional standard process that we go through. We can just jump the provisional here, go straight to the complete. We can drop the provisional here, we can go straight to PCT, or we can even go straight to the national application if you want. So what we do as attorneys is we talk to you what it is that you want, where do you need, where are your markets and things like that, and then we decide what's going to be the best course of action for you. So that's the process. And I guess one of the other things that I talk to clients about is a patent's not going to make you $1 million just because you filed a patent. So there are some people there who think that all I've got to do is get my patent and then I'm home and hosed, I can retire and yes, enjoy the beach every day. But what you've got to do is work out, you've probably got the harder bit to do now is actually get it commercial, but certainly a patent can be valuable. And I think I'm getting behind my timing. You're probably all aware of Amazon and their one-click option here. So they have the option that rather than going through and putting something to a trolley, checking the trolley, then paying for it and waiting for your order, you can do one click and all that happens. And they went and got a patent for this. Now, at the time, we're talking about the late 90s, this was very unconventional thinking. The public were very fearful of shopping. You may recall back in the times we basically, no, don't put your credit cards in. Those bad people on the internet, they're going to steal all of your money. And so that was the environment they were in. The other thing that was interesting for them is that half of the shopping trolleys were abandoned before they were actually checked out. So you imagine you're going to Coles, 20 people going to Coles, they fill up their trolleys, and then 10 of them just leave the trolleys and walk out, and only 10 of them buy it. That was the issue that Amazon faced. They also knew that in the last 6 weeks of the year, so the Christmas period, their customer base increased by 20%. So having a patent over one click was commercially valuable to them. Barnes & Noble came out after Amazon, copied it basically, and they were also calling it one click. Amazon didn't like it and filed a court action against them to try and stop them. Not surprisingly, Barnes & Noble tried to reschedule it for after the Christmas period. The interesting thing is that Barnes & Noble always referred to it as one click. The only time they didn't refer to it as one click was in the court hearing. The court found for Amazon and stopped Barnes & Noble. Barnes & Noble appealed and it went back and forth. It was eventually settled in 2002, but before that time, they couldn't use one click. So the value of the patent here for Amazon was great. It kept their major competitor effectively from using that technology for a number of years. What's also of interest is that in the same time frame, Apple, they took a license in 2000 and so they could use it. Another example of patent that was valuable is Apple actually went and got patents around the Apple Pay and transit cards. And you may recall back when the Australian banks were trying to force Apple to do a collective bargaining. So certainly that put Apple in a strong position. But innovation is not everything. Kodak actually were the first people to invent a digital camera. But they were so strong on their film industry, on their film business, and they thought that was everything, that they weren't interested in pursuing the digital camera. Nokia, they were the top dog in mobile phones. They were coming smaller and smaller and better, and they had all the patents and they had the market. And Nokia just thought some young upstart with a bigger phone, flat screen, and poor battery life was never going to do anything. And certainly they disregarded Apple when they came in. And history shows that Apple is now much stronger and Nokia is probably still struggling. So patents can have value, and the value that they can bring can vary whether you're a large company or you're a startup. If you're a large company, you want a patent to stop your competitors doing things, or you might want to be able to cross-license. If you're a startup, you might want it to do some capital raising and have investors believe in you. If you're thinking about other companies, back in the previous lives when we used to be able to travel, if you went to the US and you saw TVs, almost every second advert talked about this patented technology, this patent invention, and it was seen as a badge or reputation that must have value, that it must be unique. And so the patent there is more marketing value than anything else. A startup might want a patent for an exit strategy. So there's various versions and reasons why you may want a patent, and depends on both your company size, how mature your company is, and what it is you've come up with. And I will always ask clients when they come to me why they want a patent. It's important both that hopefully the client's thought about it and they're not just coming in thinking it's going to make them $1 million. But also it helps me understand what it is they're trying to achieve. If it's a mature company and they tell me that company X keeps on copying everything they do and they don't want them to copy this product, then I'm going to look at it a bit differently if they just come to me and say, yeah, look, we know it's pretty thin. We just want to be able to say that we've got a patent pending for marketing purposes. So my approach could be slightly different in that. You also need to think about, the market and the market size. I had a client come to me once and they had an invention that was particularly applicable for the Navy in detecting their submarines underwater. In Australia, you think about it, they had one customer, the Defence Force. Once that customer bought it, there was nobody else to sell it to. They didn't need a patent, they just needed to sell it to the Defence Force. So it's actually recognising, other aspects of why you might want it. Certainly it would have been a great patent. It was very technology driven. It solved a huge problem that was out there, but there was just no need for a patent. And there's other things that you talk about as well. Is it a really crowded space? How easy is it going to be? Can somebody reverse engineer? If they can't reverse engineer, then actually perhaps keeping it as a trade secret might be more valuable to you. Because you remember, if you file a patent, you're actually disclosing your invention. And so there's a number of different considerations that you might make when you're going through it. So it really is a strategy. It's an asset that you can use, and that's what you're doing. If you're a limo driver, your main asset is your car, and how you treat and look after the car is something that you need to consider. And you're going to manage. When are you going to get new tires? When are you going to go and service it? And a patent is exactly the same. If there's value in filing a patent, then file for your application. You've got your patent. Is there still value in you keeping the patent? If yes, great, keep it. If not, then let it go. And it should also work in with other things that you've got. As an example here, quite often, if I've got somebody who comes in with a new app, let's face it, every app out there has got umpteen others that probably do exactly the same thing. But what we might do is we'll file a patent application so that they can say patent pending. Hopefully it's going to at least delay competition while people assess what the risk of infringing the patent is. Now in that time, hopefully we can build up our reputation such that it's our reputation that people want to come to, and they don't need the patent. If you think about Angry Birds, there are a lot of other games on the App Store about knocking things over, but people know of Angry Birds. Candy Crush, there's a lot of match 3 type games out there, but Candy Crush is the one that's been monetized the best. So all you want to do is actually build the reputation, and it's the brand and the trade that's important, not the patent. The other thing is that technology evolves over time. And you need to sort of think about that and what you're doing. If you think about, before Google and Facebook, Microsoft, back when we actually used to have to put the disks into the computer to download the software, for Microsoft, it was the license that was important to them. Google, it was what were people searching? What was all the information that they had? That's what they wanted. Facebook, it's your data. That's what they want, and that's what's important to them. So technology evolves, strategies evolve, and the way that you do patents should also evolve. And one of the other things, obviously, is that you don't want as an industry to be reinventing the wheel. There's no point spending time and money and resources researching and developing an invention if somebody's already done it before. And in this area, this is where patents can also help you. There's a great resource that's available to you that you can make use of. Now, just to give some context to some of the later slides here that we're going, back in the 1970s, the bigwigs got together and came up with a classification system for patents. And this is really just to assist searching. And you can see there's 8 categories there, from human necessities through to electricity. Now there's no electronics, there's no computer software, which is probably not surprising. This was done back in the 70s, but that's everything. Every patent that's filed is going to fall into one of those categories. For most of us on this call here, it's probably going to fall into physics or electricity. Now, they're in the different areas. So within physics, which was G, one of them is computing, calculating, and counting, and it's pretty precise what falls within each of these categories. So, an example here is simulators are covered, but not flight simulators. So there's a whole heap of criteria about what is and what is not in covered. And obviously, you'd probably not be surprised, but it's broken into other areas. So if you want to look at hybrid computing, you're in G06J. And even within each of these categories, they're broken down even further into, like addressing or allocation is part of electric digital data. And so that's what it is. And we can look at any of these fields. So here's one field. So this one here is a representation of what is in G05. So that's the controlling and regulating. And it's looking at applications that have been filed since 2015. So almost 32,000 different inventions fall in this category. And what the software here has done is it's looked at all of those inventions, it's looked at the keywords, and they've plotted them all out and they've put onto this map so you can sort of get a feel for that technology and industry. And the peaks in this graph here, so where it's higher, that's all representing much more active and a higher number of patent applications. So you can see it's hard to read the wording, it's unfortunate. That's the way the software comes out. So the power, electric supply, output voltage circuits, vehicle drivers to detect. These are areas which are very heavily being researched and protected with patents and things like that. These inventions in here, well, not much is going on. And that's why you can get a feel for what's going on within that area of G05. We can also look within that area at who some of the players are and what they're doing here. So you can see here we've plotted these are some of the more significant players within that field. And you can see, Siemens are up here about, industrial plant computers. Yes, they've got other stuff up here. Certainly down here, DJI, they're into aerials, unmanned vehicles. Now they're a Chinese company, if you don't know, and so they're into camera drones. So it's probably not surprising that they've certainly got a focus down here. So you can use this to sort of see where certain players are within the industry and what they're looking at and what they're doing and who you might be up against. Just to give you a feel for another one, H2, so this is generation, conversion, distributed electric power. And again, within here, you can sort of see who some of the major players are, what are the major areas that are actually being researched and developed over the last 5 years. So certainly you've got solar panels, energy storage, as certainly sort of big ones here and here. And then, there's others as well. Where's my pointer gone? Permanent magnets down here in rotors, stator cores. And you can see who it is. So Sumitomo, they're probably saying, yes, we're going to be doing some other stuff around here, but this is our core. This is where we're concentrating and looking. And you can get a feel for what they're doing. So we can use the patents to find out what's going on and what's happening within a technology area. We can also look at it for trends and what's happening. So if we look at G06, so this is your computing, calculating, counting. In 2014, it was almost 35,000 inventions filed which fell into this area. And clearly the standout here that we've got is image processing method, so image capture and stuff like that. There's other areas as well, web page display text, search result query and other things which are also significant, but the big ones here, and that was in 2014. If we move forward, we can also see who were the players back into 2014 that were active and what were they doing back then. And this sort of plots again what they're doing. So Tencent, we're sort of through some of this web page display, Intel circuit signal integration and around here as well. And so you can get a feel for what they're doing. If we move forward to 2020, it's changed. We've got neural networks that come in. All of a sudden, blockchains come out of nowhere and is very prominent up here. At the same time, image processing method is still dominant. But if we look back at what was previously, some of the other things around the search query result, web page display, they're not so prominent these days. So clearly, companies have lost some interest in searching those particular areas. So that's one thing that you can look at there. And again, we can sort of see who the players are in this particular area. So again, all of a sudden, Alibaba have jumped into the thing. Clearly, they've got interest around blockchain. Samsung, again, their electronic, again, not surprising when you think about it, but you can use this to find out what's going. These are also relevant, I guess, if you're a startup and looking to get funding and trying to get investors and how you're trying to do it. If you're a startup now and you're in blockchain and you've got an investor, you probably don't want to be saying, oh yeah, I'm going to make this, the idea is I'm going to develop this product and we're going to be the world leader in this technology. An investor might be a bit skeptical. However, if your plan is, well, I've identified that Alibaba, this could actually really help them, so I want to develop this product and I'm hoping to be bought out by Alibaba, that might be more interesting to an investor, because when they look at this sort of data, they can say, well, actually, that business plan actually makes sense with what they can see. So we can look at what the technologies are, we can look at what the trends are and how things are changing. And I guess that also, you can also look at it saying, well, hang on, am I now in an area which is declining? Do I still want to be in this area? Is there still value to me? Or, wow, I'm an earlier adopter in this area, I've got to be on my game. But we can also look at the particular technology areas. So image processing method, it was dominant in 2014, it's dominant in 2019. We can actually focus in and have a look at image process method and see what comes up there. So if we look at that from memory, this was only looking at patents in 2019, so just under 6,000 inventions. And again, in here, we can see just within that field, what was really being developed and what was being focused on in that particular area, and who are the players that are in there. So, you can see now that Oppo, they've got a bit down here. Again, even so, it's image capture detection. That's really where it is. And what we could do if we wanted to, we could even drill down in image capture detection and see what it is that people are focusing. What are they really looking at there? Same, or if we wanted to look at human face image, what aspects of it are they looking there? Is it actually identifying the face, or is it looking at the features of the face, and how is it looking to do it? So we can use patents to look at subject matters within areas. We can look at for who the players are in an area. We can look at for what the trends are. We can drill down into certain technologies and particular areas of interest, but we can also use it to look at what various players are doing. So if we think about Samsung, back between 2010, 2014, they filed 46,500 different inventions on a range of technologies. Not surprising, they've got air conditioner heaters in there, semiconductor devices, user display screens. And this shows where Samsung were focusing their efforts back in 2010, 2014. If we jump forward to 2015, 2020, in that time frame, it's almost 39,000 inventions they've filed. And can you see where their focuses have changed? So there's a little bit less on the air conditioning. There's more now on battery lithium and some of these other aspects of there where they're changing. So they're evolving. And so you can actually look at that as being seeing, well, where is Samsung going? Is that where technology is going? Do I want to follow them? If they're a competitor of yours, you can actually look at what they're doing. You can drill down into more areas and see what they're focusing on. Are they coming into my area of interest? How am I competing with them? So certainly you can use the patent system really to look at what your competitors are doing and try to make sure that you're hopefully one step ahead of them. So the system is there. It's there that you can use it to protect your inventions. You can use it to prevent somebody copying you. You can use it as a tool to try and improve your marketing and your reputation and be seen as innovative. You can use it to try and improve your prospects of getting capital investment. But you can also, on the other scope of it, you can use it as an intelligence source and a way of monitoring what your industry is doing, what your competitors are doing, where technology is moving, where are the developments out there, and you can really scope in and look at what people are doing. So I know I've raced through a lot of that, but I was conscious of trying to leave time for some time. So thank you very much for your patience, for putting up with me and listening to me. And I'm happy to take questions on any of that or the patents, or I guess IP in general.
Thank you very much for your interesting and contentful presentation. We enjoyed a lot. So this is the time for the audience to ask questions about the patent, IP, etc. from Paul. So please feel free.
Hello, my name is Gary. Can I have a questions?
Please do.
Just wondering, roughly, how much does it cost to apply a patent?
Yeah, it's not a cheap exercise, and I'm going to be a bit of whiffle waffle here and say it really does depend on the circumstances, and you might be surprised. For example, a nappy can be very high tech, and there's a lot of stuff in there. So a lot of it depends on how much material there is, how much time is required by the attorney involving, and what I would say is I'd come to you, but I would expect at the very least you'd probably be looking at about $7,500 to prepare and file that provisional patent application and start the ball rolling. And then costs can be a little bit exponential there. Where it really gets into more significant costs is if you have filed an application in numerous countries. There's a high filing cost to go to, if you're going to go to a number of countries, and obviously then you're managing a process on. So it's not a cheap process, and that obviously needs to be taken into consideration when you're looking at whether it is worth it for you. But yes, not cheap, but it can be valuable, or depending on what you're wanting to achieve from it.
Okay, thank you.
Thank you. So please feel free to ask your question from Paul. So I have a question, Paul, from the academic side point of view. So I would like to know your recommendation for the forwarding and navigating the, for example, research outcome toward the patent. So what's your recommendation and the best way, and the where can we start, and what is the procedure? If you answer this one, thank you.
Yeah, look, it's and some of it depends on one of the things that researchers like to do in a lot of areas is publish, and you want to be published and be recognised for what you've done. So, but if there's commercial value in what you've researched, what I would urge you is to try and sort of at least delay that publication until you've considered whether you've patented it, because obviously once you publish, then you're not going to be able to get a patent, and you may have missed that opportunity. I think there's a lot of idea about trying to partner up with industry, because obviously if you're a pure researcher, the difficulty you're going to have is perhaps funding, not only for your own research, but to also file the applications and the commercialization of it. So that's where you're going to need some investors. So it's a difficult question if you are a pure researcher, because the reality is that the funding's the biggest problem. And that's where I think you perhaps need to identify the commercial opportunities and look at who you could partner with to take it further in that respect. So I'm not sure that's answering the question, but that's
yeah. Thank you very much for your answer. Yeah, we know that the funding is very important, and working and linking with the industry is a very important thing for the academic as well. So we are still here in the sessions, and please feel free to ask your questions. That is very interesting topic, and I think everybody can benefit from the advice and recommendation of the Paul. Okay, I think there is no more question. Do you have any final word, Paul, before finishing the session?
No, look, what I would suggest people is that if you are innovating and you are researching, you can always talk to a patent attorney early and just get an idea whether this is something that to be looked at and what you need for it. It really comes down to identifying what your technical problem is and what your technical solution is, and think about whether a patent has value to you or what you're trying to attribute to. So at least think about it. It may not be for you. It may not fit your needs. No problems whatsoever about that, but at least be aware of it. It could certainly be a very valuable tool for you. The Amazon example there was an example of where it's quite simple, and they only needed it for a couple of years, and it certainly would have paid dividends to them. So use you can use it for the research as well. So it's a resource that's available to be used.
Okay, very good. Thank you very much for your recommendation, and thank you everybody for attending this webinar. Would like to see you in the next one, end of the November. Thank you very much again, Paul, for your interesting presentation and your talk. Cheers.
Thank you. Thank you very much.
Thank you, everybody.
Thank you.